Let's talk about the biggest difference between civil cases and criminal cases. So, civil cases have vast amounts of discovery, right? You can take depositions, you can send interrogatories. You pretty much know what the parties are going to say, what the people involved are going to say before they come to court and say it. And if they change their story at court, you can say, look, last week we interviewed you, or last month or last year, and you said different. Criminal, a whole different ballgame. We do have discovery. The defense is going to get witness statements if they exist, right? If they're interviewed, if they're recorded or written down or whatever it may be. But for the most part, in criminal, we don't have the ability to compel people to do an interview or a deposition or anything like that prior to the trial, which means for a vast majority of the witnesses, you don't know what they're going to say until they say it on the stand. You may have an idea and you may know the truth, but that doesn't mean that the witness is going to tell the truth. It doesn't mean that the witness is going to remember things how they remembered it originally. Doesn't mean that you're going to not hear something that you've never heard before. In fact, most trials, you're going to hear something from a witness that the prosecutor's never heard, that the defense has never heard, that your client's never heard, right? And you got to be able to react quickly to that. So the biggest difference, I think, is when we go to trial in criminal versus when you go to trial in civil. The criminal is much more like the Wild West, much less predictable as far as what's going to be said, when it's going to be said, who's going to say it. And you've got to be able to think quickly, react quickly, and handle that unpredictable statement in a way that is beneficial for your client and that fits the theory of the case.